We're excited because we had a big win down in Texas. In this case, our client was a teacher outside of Houston who was simply praying at the pole, which is a national day of prayer where students or teachers meet outside of their schools at the flagpole before class, before any education has started, simply to pray. And her and a few other teachers were outside the flagpole praying when the principal came and rounded them up and told them they are not allowed to pray. And he said, "This is the school policy. You must stop praying. You are never allowed to pray in the presence of students at this school." That's against the law. That's unconstitutional. The First Amendment does not go out the window the minute that you become a teacher in a public school. The First Amendment gives our client the protection to pray when it is outside of her role as a teacher, outside of the classroom. When she is not officially on the clock, she is allowed to pray whether a student is around her or not. And so we took this straight into court, and we had our first win. It's not the end of the case, but the judge did side with us on what's called a motion to dismiss. And this is when the defendants decided that they were going to petition the court to get our entire case thrown out on something as basic as our complaint alone, without any evidence and without any discovery. The judge held that our complaint on its own was sufficient enough to plead that yes, our client had her constitutional rights violated by the school when they told her that she could not pray in the presence of students. The court went on to cite the recent Supreme Court decision of Kennedy, which was about a coach who was praying on the football field. And so this judge said, given the circumstances in Kennedy are similar to the circumstances here, if we take all of the facts that were in our complaint to be true, then we have successfully won our case and argued that our client's rights were violated by the school. So the fight's not over. We still are going to have to spend upwards of 30 plus attorney hours putting together what's called a motion for summary judgment. And that's our turn to ask the court to go ahead and rule on the case without having to go to a trial. In this motion, we argue that our client, the teacher's rights, were violated by the school, and we have the case law backing it, including the Kennedy case, and we couple that with all of the evidence and argue that this case should be decided in our favor now without going to trial. The backbone of the ACLJ are First Amendment rights cases in schools, going back to the beginning. And so here, we're never going to stop fighting for your religious liberties while you are in a school. Whether a teacher, administrator, or staff, you do not lose your First Amendment rights. And the ACLJ will always back you and secure you in that. We will not stop fighting when schools violate your First Amendment rights. We're here for you. We're here to defend you. You're not alone.